Good afternoon. I'm JD Houvener, and welcome to the Bold Patent Show. I'm here with my co-host, Matt Colseth. Matt, good afternoon to you.
Good afternoon, JD.
A tip of the baseball hat to you. You had a baseball. You had a hat on the past 2 weeks, so you get a pass.
Oh yeah. I'm not working on my house or under a car today, so I'm working on a desk.
So how did you go? What was your batting average, we'll say, on your house and home, or on the house and car?
Oh man, we knocked it out of the park, so we're good to go.
Good job.
We're done.
Right. Good. Getting where you need to be and living comfortably. Gotta love that. Yep. So we got a cool show today. I was just bummed. About an hour ago, we had a special client all lined up, and we're going to have to save him for another week. He couldn't make it. He had something pop up work-wise. I really wanted to show off his invention. It was a really cool baseball, of course, invention. That's our theme of the day. But I've got some interesting things we're going to take bold bites of. And they're not Shark Tank, okay? They're not Shark Tank. So different reactions, commentary, things that Matt and I will go back and forth looking at IP perspective related to baseball. So, hey, Justin, good to see you. Thanks for popping in. Good day to you. What kind of a hat are you wearing, or would you be wearing, Justin, is the question to you and any of our live audience members. Matt, let's start with you. You got a baseball team? Are you a baseball fan at all?
I'm a terrible, terrible baseball fan and even a worse baseball player. I'm so bad at baseball. When I was a kid, my coach made me bat left-handed.
No way.
He thought I'd be better left-handed than right-handed. That should tell you everything you need to know.
I wish I would have tried baseball. You know, it just seemed like football, basketball, and tennis or something kind of took over, or mainly just basketball.
Yeah, I mean, I was a soccer kid, so I played soccer, and I did that pretty well. But yeah, not baseball.
Well, I'm pretty much in the same boat. I'm kind of a fair weather Seattle guy, so I'm a big Mariners fan. Go Mariners! So W, flip it upside down for the M, call it good. I know they're in the playoffs, and actually have a cool little snippet we'll look at a little later. For those that are joining for the first time, perhaps, or are new to listening to Patent Attorneys Talk Live, I just want to let you know that while we are attorneys, we don't want you to share anything confidential. And so I've been remiss actually lately putting this notice up. So this is not the place to share your confidential invention information. This is a public forum. We're broadcasting live across Facebook, LinkedIn, and YouTube. We will take live questions as priority. And here we go, Justin. Good job. He came back to me. Atlanta Braves, since I live here now. Okay, no longer the Dodgers. Okay. I'm trying to follow that. See, I thought it was LA Dodgers. Is that true? Los Angeles Dodgers? And then Atlanta Braves. Got it. So you used to live in LA, moved to Atlanta. Got it. I'm a little slow. Gotcha. I'm still waking up a little bit. Cool. Well, Justin, if you're involved at all in baseball, if you got any questions on that, let us know. Live questions, like I said, are going to be taken as priority. We'll kind of jump right to those. I have 6 preloaded trademark questions that came in over the week for us, Matt, and 1 patent question.
Yep.
Gosh. Yeah. Well, we don't have our client on. I kind of wanted to get to these little clips. They're kind of fun. I want to see where they go. So let's jump right to it, okay? I'll share my screen, and we'll let the audience participate as well. We'll kind of just show about 10 seconds, and then I want to have a little dialogue. So here is the Seattle Mariners playing against the Houston Astros, a little clip. I want to, Matt, have you focus on intellectual property that you see in your screen right now on the freeze. It's almost like kind of like a flash image test.
Right. Yeah, we got a lot of advertisements here, right? I mean, we got DraftKings everywhere, a lot of branding going on.
Okay.
Right?
What do you see? I see Google Cloud. Okay, so Google, they're advertising. These are obviously advertisements right here on screen, not there on accident.
No, DraftKings makes sense, right?
DraftKings, okay.
What's ALDS?
ALDS, that sounds like almost like a disease, but no, I think it's got a baseball on it. It's related to, I'm guessing, the American League Dental Society. I don't know. We have to look it up, but I thought it's dental. It's going to have to be.
Some baseball fans can be like, you guys are just pathetic.
Right. Exactly. Astros.com. Now, so why would they have, obviously we're in Houston.
Yeah.
You know, looks like they're putting their website on there. What do you think about that?
That's weird. What a waste of retail space.
I think it's a little bit.
I mean, they'll put logos and names and websites on anything. I mean, you can't walk into a men's bathroom today without seeing a advertisement in front of you. So
yeah.
Even when you go fill up your car these days, right? You fill up the car and there's an advertisement on the screen in front of you. It's just, yeah.
Now there's one that's sort of really hidden. I'm wondering if you can spot it. It's
the one.
down.
Oh, it's one down on the mound, pitcher's mound.
The mound, you got it. So what is going on down here? Is that a real? I thought that looks like a CGI add-on.
Yeah, that looks like it's computer generated for sure.
Okay, yeah, that would be quite a careful thing for the pitchers to have to dance around and not disrupt that.
Not get it dusty.
Yeah, but the DraftKings is legible there, but kind of a cool thing. And so that whole system, it doesn't happen automatically. So that's something that might potentially be a part of a patent or a software method. We're going to be applying a computer graphic image on a video, and I'm kind of curious to see how it looks in motion. So let's watch the CGI and see how it moves.
And Altuve on the ground, got a chance here.
Okay, it was pretty static.
Out there, throw to first, and it's a double play.
Well, that was a good play by the Mariners. That happened to be a real good spot for a good Mariners out. But that little image didn't change too much. Let's just see if we get some other.
And it's a double play.
Other angles on it.
Lead 7-3.
Okay, so from here, you got some branding in the back. Saw a Honda. Anything on the jersey you recognize, Matt?
I mean, clearly Nike is sponsoring Major League Baseball, right?
How did you know that? Okay.
You got the swoosh on it, right? And the Mariners aren't paying for their own jerseys, right? I mean,
okay.
I would think Nike was paying big money to Major League Baseball to have their brand, highlighted in professional sports.
Right. So, let's see. We got some comments here. Okay, Armando, go Rastros. Okay, all right. Got a Houston fan. Good to see you. We got a correction. Okay, Armando.
Yep.
American League Division Series. That makes a whole lot more sense.
Yeah.
Thank you for that. And we got Justin. Did someone patent the home plate rectangle? You know what? I'm not a baseball player, as I mentioned, but I don't think it's an actual rectangle, Matt. Isn't it a diamond?
Is it a Pentagon? The home plate?
Pentagon. Let me see. We have to draw it out.
I thought the home plate was a Pentagon.
Five sides. 5 sides. Yep. Justin, you've been overruled, my friend. But let's rephrase it. Did someone patent the home plate Pentagon? You know what?
Let's
go to my friend Google, and I go to Google Patents. It's patents.google.com. Home plate. I don't know. Home plate. It's going to take too long. It's going to take a long time. I don't want to take.
That search is going to.
We're live. Let's see if I can just do something really wacky here. Status granted. No, I'm not sharing my screen. U.S. patents. Whew. Hard to say. You stopped me. Good question. Might have been a long time ago. Let's do the next one. Are you ready, Matt?
Let's do it.
Okay. We're going to go to a common scene, in sports, and this is a specifically baseball one, where there's interviews, right? A little post-interview session. It's pretty trademark focused, but I wanted just to see what your thoughts are.
For Matzik. He's.
We don't actually need to hear what he says. Let's do the. I like the guy. Nice gentleman. So, what are you noticing here? What's glaring? What's maybe a little bit more disguised?
Yeah, product placement, right? So a lot of these companies are going to have agreements with companies like Gatorade, right, where they're required basically. When they get on stage, someone's going to hand them the Gatorade, right? You got the Major League Baseball symbol in the background.
Now, this doesn't say Gatorade. How do you know this is Gatorade?
It's got the orange cap, man.
Orange cap? Well, what do you mean? That's not a trademark, is it?
Oh, it certainly could be, right? There's when we talk about like design patents and trade dress for trademark purposes, that design of that bottle from a consumer recognition standpoint can be trademarked, right, as trade dress. So the shape of the bottle, the cap color potentially, if it's distinct enough in the marketplace that you can show someone the cap and they're like, oh yeah, it's a Gatorade cap because it's orange, right?
Orange cap. So you're telling me if I go out and start selling lemonade and I got that orange cap, I might get a call if I start being.
You might. I mean, how many orange caps besides Gatorade do you know? Right? And why is that? I don't know. I don't know if Gatorade has registered that particular color for caps from a design trade dress standpoint, but it would not surprise me in the least.
Right. Okay. All right, let's do our last one here. Again, anybody that notices anything or has questions on these, I'd love to hear. We'll do one more freeze frame. So we saw the live action sports, we saw the post-game interview, and then there's this outpouring of these programs, right, that are sports shows, talk shows, all sorts of different things, commentary. So this is a show, the Rich Eisen Show. Let's take a little look here. Look at this amazing amount of stuff on the desk. Holy smokes. Wow. So we could probably spend a long time, but what are some things that pop up? I mean, this is a sports show. I don't know who Rich Eisen is. I don't know which one.
Yeah, I don't know what's advertising versus just like,
I thought it was just astounding how much stuff they've got, right? And they're on air. I mean, they've got all different kinds of sports. Okay.
Yeah, books. Al Michaels, you got Brian Cranston.
Right.
Books.
You got
books. You got some coffee company or something. You got FIFA with the World Cup trophy.
Okay. I didn't know what that was. Okay, that's FIFA. All right.
That's FIFA. But yeah, there's a lot going on
Latte
here.
Larry's.
You got Roku. You got the Roku channel advertising. I don't know if anyone actually watches Roku channel, but I see it everywhere. You can't even turn your Roku on without getting like ads for Roku channel. Oh, you know what that is, right? Tell me.
Ted Lasso.
Believe, baby.
We got images and likeness. I mean, what do you think the odds are of a show like this that's on, I think, whatever you call it, mainstream media?
Yeah.
Do you think they've got licenses for all this stuff, or are they kind of just hoping that nobody comes after them?
No, I don't think that they have licenses for most of the stuff. I mean, like obviously the stuff like the Roku channel, that's good advertising. The books, they might have a deal with a publication company, right? That basically requires them to display these two books or these certain books during certain times of the year. But the rest of it, it's just color commentary filler.
Yeah, got it. So if someone's out there and they want to do it right. You got to strike a balance. Maybe is kind of what I was looking at, really getting to. At some point you have to kind of draw a line. If you're going to have a business or a mainstream media company, you have to take some level of risk. And I was hoping you were going to say that, because I think that's sort of the business answer as well. You have to balance risks. You have to find out, okay, where am I, really leveraging someone else's goodwill for my own financial benefit. And with so much stuff. Maybe they've decided it's just kind of all for fun, eye-catching, kind of fun.
Yeah.
Crazy
what I think is kind of cool, and maybe this is what they're going for. So, I mean, this looks like some like sports nerd's desk, right? Like all his like favorite stuff, right?
Yeah, right.
Stuff, right? And he's got like this cool trophy. He's got some bobbleheads, some memorabilia, and then he's got these two books, right?
Yep.
And like maybe it's meant for the viewer to basically think like these are like organically there amidst all this other stuff that he really loves. Yeah, like these are his two favorite books, right? And if they're good enough, for him, they're good enough for me, right? I should take a look at them. Maybe that's just really clever product placement.
I think so too. Justin commented, "I love it. Always, you're looking for me. I should be commenting on this." But he said the helmet face grills could be patented. Absolutely. I mean, helmets have come a long way. Yeah. I think kind of a lot of that celebrity. I mean, after the Will Smith movie, a lot of that information about concussion protocol. Helmets have been on high demand in terms of reducing load to the brain. And you always hear the quarterback. You see the quarterbacks, covering their earpiece because there's wireless communication going on inside the helmet. A lot of technology on the grill. I know we're not talking football today, but we're talking baseball. I thought it might be kind of fun to show a baseball patent. So we could do that briefly, and then we'll jump to our preloaded questions. And keep those live questions coming. So the place I go is Google Patents. It's a really cool place. I was looking for that question that Justin asked about the diamond. But you can just put in keywords, right? So keywords up here. You can put the priority date. I was trying to find a 1950s, like a really old priority date for a bat or for the home plate. You can select whether it's granted or still pending, what the patent office is, U.S. or any other country in the world. And so we can do what's a cool baseball term, man? What's something I should look for?
Let's see. I mean, you could look up. I'm just trying to think like innovation in baseball, right? I mean, probably cleats. Probably the baseballs I think are owned and manufactured by MLB. And I don't know if you've heard about the baseballs potentially being like they call it juiced. In the last decade or so, they've been kind of changing the formula for making the balls.
Oh, I didn't know that. Well, let's see if we can find that baseball ball.
Yeah, I don't.
Ball rotation indicator and method.
Oh, interesting.
So 10 million patents out there. Plus, there's a lot of stuff. So
this
is a utility patent. Looks like it's actually for it's a training tool. So they're trying to find out how fast are you spinning the ball as a pitcher. That's pretty cool. So instead of just the actual ball,
most of the like invention I would think in like baseball, which is 100-year-old sport, right, is going to be around broadcasting and training. That would be my take on it, right? Because at the end of the day, they're still manufacturing and throwing a leather-bound stitched ball and hitting it with a wood bat and running around bases on grass, right? So it's not like the game has, evolved fundamentally versus, even 100 years ago.
Right.
In terms of
93, there's an early one, right? Basically being able to sense how well you're hitting it.
Cool.
Transducers, seeing what ultrasonic transducers look at.
Oh, so they're trying to basically figure out like if you're home safe and like basically take the ref out of it a little bit, maybe.
Yep. Oh, I think you're right. Well, I thought it was more about swinging. So the transducers are centrally located to emit high frequency signals, and it's used to determine whether the pitch ball was within the strike zone. So it's kind of before we had the ability to watch it on TV. Perhaps you always see that box, that floating box that shows up. This is more of trying to get rid of the umpire or have some sort of a review of getting over the plate.
I love it.
It's kind of cool. So there's so many innovations. I mean, with bats themselves, like we mentioned, the ball, and it's pretty easy to go find them. I mean, just go type in. I mean, Google's incredible. Then of course you go to the USPTO website. There's a baseball bat, right? This is going back to 1973, and you can find out some recent ones. And like I said, just adjust the priority date. Let's see, bats that are patented in the past couple of years. A utility, you can still get a patent for a bat, right? This is you don't have to reinvent the wheel. Find a new core, right? A new specific type of core, for the right application, and that can be patented. Right?
Wow, cool.
Amazing to have it come up with, all these different. I know there's hooks and pulleys in here. My gosh, look at this bat. Not sure how whether it's legal or not. Right? You gotta check
no.
ALDS, but you got a spring-loaded bat. This is awesome. I want one of those.
Yeah, that's
cool.
wild.
Very cool. All right, we got someone else here. BD&A LLC. Okay, maybe he spotted something that was on the shelf earlier. Brent, if you could help us understand what that means. Looks like strike indication. Yeah, that's right, Justin. Cool. All right. Well, Matt, we are approaching our time to look at our preloaded questions.
Good.
I want to put myself on the hot seat. I know we've been doing a lot of trademark work questions so far on those bold bites. So let us look at a patent question that came in from San Jose just 5 days ago last week. All right, I'll put that in the box here. All right. Can you patent a smart contract implemented on Ethereum that achieved a specific outcome? Is it possible to patent an Ethereum smart contract that has a specific feature? Take, for example, can someone patent a smart contract that creates NFT that generates royalty revenues for the creator of a digital artwork? Assuming it's 7 years ago. So yes, you can patent the method and a process. Okay, blockchain inventions have been patented, since 2014, 13. Some of the older ones. As long as you're able to describe a novel, right, the first time it's ever been done, and a non-obvious method or process, which is just a series of steps that has never been done before that provides utility, that is patentable, right? And a smart contract is one example of using the distributed ledger that blockchain is to validate, move processes through quicker, confirm multiple parties, whatever it is you're trying to achieve. And you're saying Ethereum, but it could be really any digital currency. And you're not necessarily giving us a whole lot of details, and that's okay. But that's generally my question or answer is that yes, you can patent it, but of course it has to be unique, not just in the US, but in the whole world. And it can't be an obvious version, a simple change from an obvious iteration from a prior published patent or publication that's already known in the art. So thank you for that question there. Okay, Matt, you are up now. We got 6 questions. I'm gonna have you in the hot seat. We got 10 minutes left, and any live questions, we'll answer those as well. So we have one. This one's out of Seattle. Go Mariners!
Always smart people up there.
Absolutely. Here we go.
The smartest.
What is the typical cost? We're getting right to the money here. What's the cost to get a trademark created for a new product? If the trademark is already in use and will not be accepted by the Federal Trademark Office, is there a cost associated with that?
Yeah. No refunds at the USPTO.
No.
Uncle Sam does not give you your money back if you have an unsuccessful trademark application. So, the typical cost for a trademark application is $250 per class at the USPTO. And some folks may have heard me in the past talk about like the class system at the USPTO, but basically there's 45 classes, goods and services, everything from apparel to NFTs to legal services to online retail store services falls into one of these 45 classes. And a lot of times clients are going to be in multiple classes, and that can be one application could be a word mark, another could be a design mark to protect a logo. You can have classes for word marks and design marks. So a lot of times clients are in 1 or 2 classes, and sometimes they're in 5 or 6. So each of those applications is $250 in government fees. It gets more complicated if you're not in the marketplace yet, but you're going to be in the marketplace, because then you have to file the application for $250 per trademark class. And then when you go to market, you have to file what's called a statement of use or an accusation of use, depending on where you are in the examination process. And that's another $100 per class. So,
okay, starting to add up. Right.
It ends up pretty quick if you do multiple classes.
Okay. No, you don't get your money back. Darn. Okay. All right.
Nope. No refunds.
So if it gets rejected, and it goes abandoned, is there any? And you come back 3 years later, any benefit? Can you pick it back up, or are you basically starting fresh?
No. So the USPTO is pretty generous with what we call office actions in the timelines. So if you apply for a trademark application, USPTO is going to get around to examining it months later. And if they find an issue with the application, they're going to issue what's called an office action, which means you've been rejected, preliminarily speaking. And then you have the opportunity to correct, amend, remedy your trademark application or make an argument as to why your application should be accepted at the USPTO. And that timeline from office action to when you're due to respond is 6 months. And then if you need to, you can pay for another 2 months typically. But I wouldn't recommend it. Don't do that.
Okay.
Yeah, actually, you can't do that. So it's 6 months only. I was thinking the extension period was also 6 months and confusing.
All right.
You got 6 months. Don't blow it.
That's bad. So, okay, good. And for anybody that has more questions following up with Matt, he's just a brilliant guy, wealth of knowledge when it comes to trademarks. Quick product placement there for AHA. Did you guys catch that? Those happened quick. Very quick. Matt, no, just kidding. We're not sponsored anyway, affiliated with AHA. Matt Colseth at boldcolseth@boldip.com. And you got my email address as well. So we're going to go back to patents. I did find a patent infringement question that was hanging out. While Bold Patents does not litigate, we will help you prepare a wonderful patent that will be so solid you won't have to go to court. It'll scare your competition away. Looking for a patent attorney licensed in the state of California. Hi, I'm looking for an attorney licensed in the state of California for an infringement case. Where there is clear infringement. Very generous contingency fee offered. That is cool.
Intriguing.
I didn't quite catch the question there, other than hey, you're looking for more. Now, what I will say is this is actually pretty typical. Where there's an inventor, they see something even remotely close to what they have got a patent on. Oh, they're infringing. Oh, I'm taking them down. I need a litigator right now. Okay, let's put the brakes. Let's pump the brakes a little bit. And I would just advise this inventor to get an opinion from a patent attorney first before firing off a cease and desist letter, riling up the bees, the hornet's nest. One of the most things inventors forget about is that they don't own the specification. They don't own the drawings. They don't own the cover sheet. What they own are the claims. Okay. And I'm going to go back to this example. I'm going to go real professorial here. Let's go back to this bat. Okay. You see this really cool core, right? There's, all the spring loaded, you're going to just, you're the owner of the world. You're going to be able to block out any other bats. But what they actually own is the claim here. Okay. And we'll zoom in on the actual claim language on claim 1. A bat comprising means has to have at least these 2 major elements, and then it can have anything else. A tubular frame having circular cross section, having a large diameter hitting portion, intermediate tapering portion, and a small diameter handle portion. And then an insert, a tubular insert, having a plurality, which means multiple walls, right? Large hitting portion, air gap between the tube insert and the tube frame, first diameter and a second diameter, right? All these different specific features. And if you happen to have an insert that was not tubular, had one square edge to it, all of a sudden you're not infringing. Okay, so it'd be really important to take a look at your claims to make sure that the product you think is infringing actually meets the elements, right? The English definition of your claim language. So it's almost always worth it to get an infringement opinion before getting all excited and starting to sue. So once you get to that point, the second thing is not actually to move forward, even if they are truly infringing, it's to make sure you still get a valid patent. A lot of times what can happen in the patent prosecution is you end up either on accident, if you filed it on your own, you can end up saying a lot of things when you're arguing or with an interview with an examiner where you give up your rights. And some things are not actually all part and parcel into the patent document. You can actually give up rights. If you say, oh, well, we're definitely not doing this, and we didn't invent this aspect. If there's any point to where you're affirmatively stating that you did not invent a portion, then anything related to that, you won't be able to get rights on. So it's worth looking at validity as well before infringing. All right, Matt, just a couple minutes left. I wanted to also offer our 20-minute free screening session for those that are viewers on our live show. This is for a free opportunity to talk about what you've got, whether it be a patentable product or a new brand you're looking to roll out, to see if the time is right to move forward. And we put you in a way on the phone and hear your story, see if it's a case that we can help with. And if it is, we'll schedule you with one of our patent attorneys or with Matt Colseth on the trademark side. And just for taking action, we're giving you a copy of the book right behind me, Bold Ideas, The Inventor's Guide to Patents. I'm the author there, so that no extra licensing are needed there with that book. Matt, any final words before we close out our show?
No, I mean, I guess the one thing I would say about like the trademark infringement side of things is that I get this question a lot. I have somebody who's infringing my trademark. I want to sue them.
Right.
How much do you think it's worth? And I always say, like, for you or the attorney, because when you sue someone for trademark infringement, the expectation is that you're not going to get any money necessarily for that infringement. You're going to get an injunction from a judge that says that they cannot use that name anymore. That's what you're getting. You're getting them to cease and desist. You're probably not going to get some money unless the actions were egregious. So that's one of the key differences typically, I think, between patents and trademark infringement is that one may be worth some money, the other's not.
Interesting. So damages, you're saying, are from what you've seen and heard and know, are for the most part lower than on the patent.
Yeah. Yeah. You're not going to find trademark attorneys who are going to typically take cases on contingent fee basis, 30%, 35%. That's just not going to happen. There has to be bad will. There has to be, bad faith. It has to be, public notice of the trademark. There has to be a whole bunch of bad behavior that goes into treble damages, punitive damages, attorney's fees, that sort of thing.
Yeah, awesome. That's really cool. So kind of, the process is get with an attorney to make sure you're actually infringing. There is infringement. Make sure it's valid. And then thirdly, make sure it's worth it, right? Is it worth the investment? Hiring an attorney to go through it.
There's a lot of other ways to get people to cease and desist other than taking them to federal court, right? Today we have social media, right? And that's controlled by trademark registrations, right? If you have a trademark registration, somebody's infringing it, you can go to Facebook, Instagram, LinkedIn, TikTok, and ask them to take trademark pages and handles down. So there's other levers you can pull besides taking someone to court, which can cost a lot of money.
Right on. Matt, thank you so much for coming on today. And for all of us here at Bold Patents, wishing you guys a wonderful afternoon. We'll see you next Wednesday. We're here live every week, 1:30 Pacific, 4:30 on East Coast. Have a good day, everybody. Go big, go bold.